Good morning, everyone, and welcome to episode 3 of the Eversheds Sutherland PROPcast series. My name is Carolina Andresia, and I am the professional support lawyer to the real estate practice group here at Eversheds Sutherland. Today's topic is minimum energy efficiency standards 1 year on. Some housekeeping before we start. I have muted everyone's telephone line on entry, so hopefully we shouldn't get any background noise. If you accidentally come off mute, perhaps you would be so kind as to mute yourself again. With so many people on the line, it can get quite noisy. Just because we've put you on mute doesn't mean we don't want to hear from you. There is a chat function on the WebEx, and please feel free to add any comments or questions as we go along, and send those to either everyone or just pick up my name, Caroline Andresia, and it can arrive at just my chat box. Depending on where we are in the presentation, I might pick up your question there and then and deal with it. Any questions I haven't dealt with by the end of the session, I will stay on and pick up and answer then. I'll endeavour to finish promptly at 9:30, but will stay on for as many questions as I need to. A reminder that the session is being recorded and will be available to listen again or to direct colleagues towards via the PROPcast page on the Eversheds Sutherland website. Right, with that housekeeping over, we'll turn to the topic in question, minimum energy efficiency standards 1 year on. Slightly more than 1 year, it was the 1st of April 2018 when these came into force. And my plan in this session is not to rerun all the law and detail of MEES, as they are commonly known. I will do just a quick run through of some of the law behind energy performance certificates, EPCs and MEES, just for the context. But I won't consider any of that technical law in detail. If you would like a recap on the law, then you can visit the ABC training pages on our website for the recorded webinars that we delivered last year on the topic. There were 2 of them, MEES, What Everyone in Property Should Know, which was a good background, and a second one, MEES, Considerations of Strategy and Drafting. So there were 2 webinars last year that give you more of a background. I intend today to look at what we've seen over the last year when it comes to minimum energy efficiency standards, what drafting we've seen in leases, how the law has changed, where it has changed, where things unfortunately haven't changed and moved on, and to sort of see if we're settling down into any kind of industry acceptable norm in our lease drafting, or whether actually it's still rather a contentious issue. So, as I said, a quick move on to the first refresher, which is on EPCs. A quick reminder, we must always bear in mind that we're talking about a valid EPC, and that is an EPC that is valid for the purposes of the MEES regulations. So that is one that is actually on the EPC register, that has been uploaded and registered, that's no older than 10 years. They only have a life of 10 years. And an EPC that has not been trumped or supplanted by a more recent EPC appearing on the register. So those are the 3 characteristics of a valid EPC, and it is an important concept to take forward. On the EPC register, no longer than 10 years ago, and it doesn't apply if it's been supplanted by a replacement EPC. An EPC is required whenever a property is marketed for sale or let. But of course, in the context of minimum energy efficiency standards, we're only concerned with letting a property. There is no law at present about selling a property with any low EPC rating, as long as you can persuade somebody to buy it, I suppose. So here we're just talking about letting. You'll remember that the first EPCs were first around 2007-2008, so it's very likely that some have expired or are close to expiring. And it may be that there has been no need to replace an EPC since that initial EPC, because the property hasn't been sold or let since then. So it may be that a property has been sold or let sometime a while back. It was one of the first EPCs, and now no longer has a valid EPC and has no need of it until it is next sold or let. There are some exemptions, and actually the exemptions have caused more conversation than I would have anticipated over the last year. Because of the importance of determining whether or not an EPC and then the knock-on effect to mean that you have to comply with the MEES regulations. So if we can avoid an EPC, we can avoid MEES. So actually the whole EPCs exemptions has become a bit of a more live issue. So premises without walls and without heating or air conditioning, they don't need an EPC, therefore are not subject to the MEES regulations. And I would have thought that would have been quite a sort of simple question, premises without walls or without heating or air conditioning, but we've had to consider storage units of various sorts, storage cages, the kind of storage racking you get, and to decide whether or not those are premises that need an EPC. Temporary buildings, that is another exemption that doesn't need an EPC, buildings due for demolition, that kind of thing. And then the rather possibly contentious one of lease renewals, because there's nothing in the EPC regulations that suggests the lease renewal under the 54 Act or otherwise doesn't need an EPC, but there is a paragraph in the government guidance on the EPC regulations which states that you don't need to commission an EPC to renew a lease. It is a very popular paragraph in the guidance, irrespective of the regulations not following through. So that continues to be relied upon, but continues to be a dichotomy between the regulations and the government guidance. So that's bearing in mind what an EPC is. We'll just have a quick reminder of MEES in itself. Key dates, of course, was last year, 1st of April 2018, it became unlawful to let a substandard property. I'm going to refer throughout to substandard. At present, that is anything below an EPC rating of E, as you'll remember, so the Fs and Gs of this world. But actually, it's anticipated that the level will be raised over time as the government raises the EPC rating in order to meet our greenhouse gas emissions targets. So we'll refer to substandard. At the moment, that means the Fs and the Gs. That may change over time. Then the next key date, 1st of April 2020 and 2023. The first date is residential. The second is respect to commercial property. We will mostly be considering commercial drafting and situations in this webinar. I will just touch on residential because there has been a change in the law relating to residential MEES in the last year. So that's the so-called hard start. We had the soft start in last year, and the hard start is 2020 or 2023 when it becomes unlawful to continue to let a substandard property. As I mentioned then, EPC rating below an E. But of course, the key thing to remember is there's no need for a valid EPC. MEES do not apply. Okay, so let's hold that in our heads as we go forward. That's one of the complications that gives us the scenarios that come up. Okay, so that is our reminder of the basics of MEES and a quick look at exclusions and exemptions, because of course these have been looked at more closely in the last year when we've come across issues to see whether or not we even have to comply with the MEES regulations or whether actually we can make use of an exemption. Lease is granted for a term of 99 years or more. The MEES regulations don't apply whether or not you've got an EPC, have a valid EPC, but it doesn't apply to leases over 99 years. And it doesn't apply to leases granted for a term of less than 6 months, with that kind of 54 Act caveat that if you can renew or if you've been in occupation for more than 12 months, then you will be caught that kind of anti-avoidance method. So very long leases and very short leases, you just don't have to worry about MEES, and if they have a very poor substandard EPC rating, no matter. Licenses to occupy aren't covered by the MEES regulations, and the whole lease license distinction has been given more fuel to that fire by the MEES exclusion. Of course, the distinction between leases and licenses and the furor it causes is nothing new because of the 1954 Act and the issue of security of tenure, and because of stamp duty land tax and the difference between paying tax on a lease and not having to pay it on a license. And now, of course, added into that mix is whether or not you have to comply with MEES. Depends on whether you categorize an occupational situation as a lease or a license. And especially on the rise, I think, when we have the kind of more informal co-working arrangements that are becoming more common, with a lot of advantages to be able to argue that such arrangements are licenses rather than leases. But it is very much a live issue. It is not just a technical, lawyer, academic, semantic issue. There is plenty of case law still happening on the lease license distinction, and you are probably brave if you jumped the side of a license when something is actually more a lease, because then you'll be avoiding your tax possibly or not, and you may or may not be breaching the MEES regulations. So that whole discussion around licenses to occupy, there have been even more of them now because we're considering not just from 54 and SDLT purposes, but also for MEES. So exclusions also include, sorry, my slide, there we go, agreements for lease. And that's important to remember too, that actually you can enter into an agreement for lease, a contract, and that can be a perfectly substandard property. There is nothing unlawful about entering into an agreement for lease of a premises that has an F or a G rating. It is the grant of its lease itself that would be unlawful if the premises are substandard. So the 99 years and the terms of less than 6 months just fine. It tends to be the licenses that cause most conversation, and the agreement for lease, which has led to some of the structuring we have seen over the last year in our lettings with regard to MEES. So then looking at the exemptions, if the MEES regulations do apply, but if a necessary consent in order to carry out the energy efficiency improvements isn't available, the landlord can register an exemption. And that, of course, could be that the tenant himself will not allow the landlord in to carry out the work. So that is an important exemption to remember. If the tenant won't let you in to do the work, you can claim an exemption, and that is the basis of the lease drafting we see in the model commercial lease, which states that the tenant has absolute discretion whether or not to allow the landlord in to do these works, but if the tenant allows the landlord in, the tenant will pay for those works, and if he doesn't let the landlord in, the landlord can register an exemption. It's not a very green way of drafting, possibly, but it's the way the MCL works, and it's the way that many landlords and tenants are proceeding. And the second exemption to particularly note is when the landlord is obliged to grant a lease, he gets a temporary exemption of 6 months. If the necessary consent isn't available, it's a 5-year exemption unless the tenant in occupation, and it's the lack of tenant's consent you relied upon, unless that tenant changes, so assigns his lease or surrenders or something like that, and you get a new tenant, you'll have to ask and be denied consent all over again. And that should last 5 years subject to that. But when obliged to grant a lease exemption is only 6 months, and that would be where the landlord is obliged to grant a lease under the 54 Act, perhaps under an agreement for lease, a contractual obligation to do so, perhaps a tenant's option to renew a lease, like we discussed in PROPcast episode 1, or possibly where he's obliged to grant a lease under the overriding lease provisions of the Landlord and Tenant Covenants Act 1995. So let's hold in our minds those two particular exemptions, where the necessary consent isn't available and where the landlord is obliged to grant a lease. The latter, he'll have 6 months to either do some work and bring the substandard premises up to standard, or else find a longer term exemption that he can register. Okay, so that's our background. The law 1 year on. Well, what hasn't changed, unfortunately, is plenty of the confusion. If you were on last year's webinars or have been reading articles and what have you relating to MEES over the course of the last year, you'll remember that there is a great deal of confusion around whether a listed building needs an EPC and therefore needs to follow the MEES regulations. The concept of voluntary EPCs, which was introduced by the government guidance on the MEES regulations but has no place in the regulations themselves, and then the issue of lease renewals as to whether or not a lease renewal requires the commissioning of an EPC where there isn't one anyway. None of that confusion has been cleared up, unfortunately, so we are left in the slightly muddy waters that we were last year in the law relating to commercial property, in particular listed buildings, voluntary EPCs and lease renewals. So over the course of the last year, it is safe to say there has been minimal, if any, enforcement in England and Wales. There's been minimal enforcement of providing an EPC, minimal enforcement of the EPC regulations themselves, and then as a consequence and a follow-on from that, minimal enforcement of the MEES regulations themselves. Minimal, if any, probably, to be honest. The relatively high fines and the name and shame remedies and enforcement action that local trading standards can take don't seem to have been used. But there are buildings that have been improved. There are statistics to show that the number of properties after an F and a G are lower than they were before. So the regulations seem to be having some effect, even if they're not being enforced. And obviously, that's got to be a good thing. And I think, fortunately for us, the Eversheds, Sutherland, the majority of our clients seek to be law-abiding rather than to get away with things anyway. So in the face of minimal enforcement, we're all still complying with the regulations. What has actually changed when it comes to the law is a slight change in the law relating to residential lettings and minimum energy efficiency standards. As I mentioned, we'll be discussing commercial situations and drafting, but I'm just going to mention this from a residential point of view. It used to be, when the regulations came into force, that a residential landlord could claim an exemption and let a residential property if there was no cost financing available, by which I mean a sort of Green Deal finance or an energy company or a local authority financing package available, whereby there was no upfront cost, it was just the costs of the works were recovered over 7 years. But actually, it turned out that these sources of funding were very few and far between. The government residential Green Deal just didn't take off. Local authorities and energy companies didn't provide these kind of packages of financing, and really effectively it meant that a landlord could let a residential property and claim the exemption every time, however substandard the property, and that was just making no difference at all to residential lets. So amendments to the regulations were made, and now for the letting of a residential property, a landlord actually has a positive obligation to spend up to £3,500 of his own money. So it's not no-cost financing anymore, but £3,500 of his own money in an attempt to bring a property up to at least an E rating before he can claim that exemption. And that was an amendment to the regulations that came into force on the 1st of April this year. So that's the law that has changed, just a note on residential situations. Okay, so now looking to commercial situations and what has changed. I think we've seen some interesting use of exemptions during the course of the first year of the MEES regulations. We have seen government guidance published on registering exemptions. Remember that you just upload your paperwork. There is no approval of an exemption. You don't get something back to say, yes, absolutely. It's a sort of self-assessment of your exemption. But the guidance does tell you what sort of paperwork, what kind of evidence you have to upload. So if you are considering registering an exemption, you need to get that guidance out and follow those rules. So what we have seen over the last year is a kind of combination of exemptions which has at times allowed substandard property to be lawfully let. So if we combine two exemptions, an agreement for lease exemption, which as I mentioned gives the landlord 6 months, and then follow it up by, say, a lack of tenant's consent, longer term exemption, it is possible by working with the regulations, by claiming two exemptions one after another, for a landlord to lawfully let substandard property. Now, this is not for everyone. This is not for every landlord, and it's probably not for every tenant in that they'll be looking to be let energy efficient premises that they won't be paying high energy bills for. But we have seen it on occasion, perhaps where there is a valid EPC in a situation where a lease is to be renewed, and so the MEES regulations apply because there is a valid EPC, even though perhaps one wasn't commissioned for the lease renewal but just happened to be there. And we've seen this in situations perhaps where a tenant just wants to stay on a little bit longer after the expiry of their lease. Perhaps the property is due for redevelopment or refurbishment and is falling below an E rating. The landlord is very willing to let the tenant to stay on a bit longer. The tenant is very keen to stay on a bit longer. But without registering an exemption, that short-term extra little letting of, say, 6 months to a year to help both tenant out and to bide the landlord's time, that would be unlawful if the premises were substandard. So by claiming the agreement for lease exemption first and then the lack of tenants exempt exemption, you can combine the two to make a lawful letting. Now, the agreement for lease one as an exemption is only 6 months. It is rather odd. There is nothing in the regulations to say that the agreement for lease has to have been entered into for any particular purpose. It doesn't have to have been entered into before the regulations came into force. The government guidance, but not the regulations, but the government guidance talks about that exemption covering a situation where a contract was entered into on a contingent basis, but that doesn't really mean anything. Possibly they're trying to say that it was some kind of conditional agreement for lease, but plenty of agreements for lease aren't conditional. The regulations, you don't put any spin on the kind of agreement for lease it has to be in order for the landlord to be able to claim the exemption. So even if you just have an agreement for lease one day, to complete the lease the next day, it seems that landlords can claim that temporary 6 months exemption. It doesn't have to be conditional on landlord's works, it doesn't have to be conditional on tenant's works or planning or VP or anything like that. You just need a contract that puts the landlord under obligation to grant the lease. If you then combine that perhaps in the scenario we were talking about where a tenant just wants to stay on for a little while, then if you draft the lease in the model commercial lease format to say that the tenant doesn't have to let the landlord in, then the landlord can ask, the landlord can be refused, and then the landlord can register a longer term exemption. So as I said, this combining isn't for everyone. It does mean that you have to register 2 exemptions, one after the other, but it does give the possibility of getting people out of a stuck situation where everybody is very willing to let and willing to stay, even for a substandard property, to let the letting go ahead. So that's what we've seen on combining exemptions. Let's have a quick look at lease drafting. We've seen quite a few clauses like this, where a tenant is trying very hard not to be in for any costs at all in relating to the MEES regulations. It's perhaps the most extreme tenant position we've seen. And I think sometimes it's a bit unnecessary. It talks about the landlord not being liable for the cost of carrying out works or anything like that. But of course the MEES regulations don't compel anybody to carry out work. They just make the letting of substandard property unlawful. You don't actually have to do work. But we've seen lots of variations on a theme of this complete blanket, I will not pay, I will not do work scenario. So then moving on from that extreme, say, tenants' alterations covenants in particular have been the source of much negotiation and refinement over the last year. When it comes to MEES, they go across the spectrum from no alterations that reduce the EPC rating. So if you hand over a property with an EPC rating of an A, then the tenant can't do any alterations that reduce that, although of course that A is well above the minimum. The landlord isn't going to be in breach of the regulations. And also, despite the fact that it is nearly always the case that there will be a covenant on the part of the tenant to reinstate those alterations at the end of the term. So even if they did some alterations that reduced the property's rating to, say, from an A down to a D, if they then remove those alterations, then theoretically the landlord should be handed back premises pre-alterations and with a good EPC rating. So we've seen that as a sort of starting point, no alterations that reduce the EPC rating. And then moving further through the spectrum, we've seen drafting that says that no alterations that leave the premises substandard, so that a tenant is free to carry out alterations of any sort as long as they don't put the landlord in breach of the MEES regulations. So as long as they don't make the premises dip to an F or a G, which obviously is going to be important to a landlord come the 1st of April 2023, when it will be unlawful to continue to sublet substandard property, then the tenant can carry out those alterations. The tenant will be the one paying the inefficient energy bills. That drafting refers to substandard or to minimum level of energy efficiency as defined in the MEES regulations themselves, so that in itself is a kind of movable feast, that at the moment you wouldn't be able to do alterations that dip the property below an E, but maybe in a few years' time that same covenant would mean that the tenant couldn't alter to dip the property below, say, a D. Further along the spectrum, no alterations that leave the premises substandard as at the date those alterations were carried out, so that actually if the rating is presently an F or a G, that's all you have to keep it to. If the rating is increased, then that wouldn't catch the tenant. And then the next line on that is no alterations that leave the premises below the minimum level of energy efficiency as at the date of the lease. So they're both kind of moving feasts. There are pros and cons for the tenant on it. They've locked down to a particular rating below which they cannot go, or else they accept that they cannot put the landlord in breach and any kind of rating goes. So those are the kind of spectrums of alterations covenants that we're seeing to deal with MEES. Then we have the pretty standard now clause about tenants not obtaining an EPC, because of course if they obtain an EPC and put it on the register, it'll trump whatever EPC the landlord had on the register, maybe for good or ill, but landlords are keen that tenants only obtain an EPC when they have to. And we're seeing kind of amendments like the one shown on the screen, so that actually it doesn't perhaps always have to be the landlord's assessor anymore. Maybe it's an assessor approved by the landlord, and of course the stronger tenants would say no, it can be from my assessor. And I think there is movement on this clause towards more of a compromise, because there is more faith in the consistency of EPC assessments, more faith in the kind of quality of an EPC assessor and the EPC that is going to be produced. So I think that drafting is moving a bit as people have confidence in the system, as the metrics, the maths, the methodology of producing an EPC is improved and becomes more standard. Landlord's recovery of costs. So the landlord does have to recover costs, does have to carry out work. Can he recover the cost? Well, we range from zero recovery as per the tenant's exclusion clause that we looked at a couple of slides ago, so we see plenty of that. We see full recovery where the tenant consents to the works. That's the model commercial lease position that I have mentioned, and the landlord can carry out the work and the tenant will pay for it. So we go from 0 one end to full recovery under the MCL. Then we have bits in the middle where the landlord can only recover the costs where the tenant is in breach of the alterations covenant. Okay, that's fair enough. You said you won't make it substandard. Here we go. You made it substandard. I have to do works to prevent myself being in breach of the regulations. You will pay. And then we see drafting which states that only the landlord can recover costs where the tenant carries out unauthorized alterations. So that actually, the tenant says, well, hang on, I got consent for these alterations. And if you consented to them, you now can't turn around and say, I've got to pay for them to be undone. So that is a sort of tenant's amendment to the breach of the alterations covenant position. And then when we're looking at the landlord's recovery of costs and the scenarios in which he can recover costs, we then see the extent of the recovery of costs, yes, drafting around that. And again, that ranges from a nice wide-ranging simply to improve the environmental performance, which is often a defined term, or the EPC rating of the premises. That's got no beginning, no end, just general improvements. Possibly the extent of recovery of costs is limited to those costs required to return the premises to a previous EPC rating. So I told you not to reduce the EPC rating and you've taken it from a C to a D. Now I can charge you to put it from the D to the C. Possibly to return the premises to the minimum level of energy efficiency. So actually don't feel that you can, run amok with my money, dear landlord, and take my premises, from an F all the way up to an A. You can just get it to the situation where you won't be in breach of the regulations at my expense, and then nothing more. And then we see things like this: to return the premises to the minimum level of energy efficiency unless a high EPC rating will cost no more or be more economical to achieve. So that's a kind of a landlord's amendment to the tenant stance that he should only pay to return the premises to the minimum level of energy efficiency. There's the kind of a quid pro quo that actually, if it's going to cost no more or be more energy efficient, let's do a little bit more. It is said that it doesn't cost much more to move a property from an F to a D than it does from an F to an E, for instance. So that's the kind of drafting we've seen over the last year. Just one last mention on a drafting point. There's the rent review assumption that the premises may be lawfully let. So there's an assumption at review that the premises wouldn't be substandard, that you wouldn't be in breach of the MEES regulations if you let that property on the rent review hypothetical lease, and that seems to be pretty standard without amendment now. Okay, so that's a canter through what we have seen and the reaction to minimum energy efficiency standards over the years. As I've said, I will stay online to answer questions if anybody wants to put anything through the chat box. And as I mentioned, the recording will be available on our PROPcast webpage. So I'll just stay online a moment or two in case anybody wants to send any questions through. Otherwise, thank you very much for attending.